Da, 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 da. Law and order in real estate, in properties, landlords suing tenants, tenants suing landlords, agents suing. We don't use the word suing much, but we're going to talk about Tribunal, New South Wales, and the birds and the bees of it all. It's not as bad as you think. Stay tuned.
I'm the ringleader, so listen up.
Good morning.
Hi, good morning on this
What do you?
cold morning.
Isn't it cold?
It's so cold.
Um, how are you, Cleo? What's been happening?
I'm good. I'm good. I'm just, doing what I do. I'm in the trenches. I'm working. I'm dropping kids off to school. I'm preparing for school holidays coming up again. Just the norm, really.
When's school holidays?
It's coming into July, so they just creep around. This year, I want to be prepared and have some things planned because we did a
That
boring lot the last one. So
that's the month. That's the month where all you Greeks go to Greece. That's the summer.
I know my dad's there already, and we promised each other we would all go as a family next year. I've been saying next year for 5 years now. So probably next year. We'll see how we go.
Book it in. Book it in.
I know.
All right. Hot topic. You do hear about it in the industry. Tenants taking owners to tribunal. Owners taking tenants to tribunal. People getting it mixed up. We want to clear up a couple of things today of what actually happens in that tribunal situation. The bare basics. Cleo, you're a veteran. How many times do you reckon you've been there?
I've probably been in my entire career probably about 30 times. I don't see going to NCAT as a failure. Sometimes it's just a means to an end. You can't negotiate anymore, and someone has to make the decision. With NCAT, the two main terminology used is probably the applicant and the respondent. So it's someone applying for whatever reason, they want their bond back, they want compensation, and then the respondent is the person going in response to that application. So often what will happen is a bond will be frozen by an agent. For example, at the final inspection, there's maintenance or damages and things, and the owner says, I would like you to claim $200, $800 from the bond or the entire bond. Whoever applies for that bond first means that they've essentially become the respondent. So I've gotten in there first, I've claimed the money. If you're not happy with that, you've got 2 weeks to apply to NCAT. So then the tenant becomes the applicant because they are applying for their bond and they're not agreeing with the agent's decision to make a claim against the bond, in which case then the agent becomes the respondent to the application, and each side has to show why they should have that money. And it's always to do with money, usually to do with money. I think moving forward we might have more to do with vacancy with the new legislation, an owner wanting their property back or a tenant not wanting to move. That side of things, that won't be about money, but I've usually turned up to NCAP over money, over claims that need to be governed by someone else.
Now, can you just explain what it is? Because I think
Mm.
most of us think court, um,
Yeah.
and they think there's a judge with the white wig on, and there's lawyers, but it's called the New South Wales Administrative Tribunal.
It is. And it's not just for real estate, it is for all consumers. So it has to do with shops, it has to do with companies. It's not it's not just real estate tenants and agents. If, for example, you're not happy with your builder, or you purchased a product or something, that's all done in this tribunal setting. The
The confusing thing for people. Sorry, Claire, but the confusing
Yeah.
thing for people is these guys have changed their names so many times over the last 20 years. It used to be Consumer Affairs,
I know. And tribunal was a big one.
tri-
I'm taking you to tribunal. You're like, what
Tribunal,
is tribunal?
Fair Trading. We're
Yeah,
going to Fair Trading.
it used to be
Um,
on Pitt Street, and it was in this really old building where they used to have a radio station also in the building.
the
And
AWA Tower,
yeah, yeah,
I think it
yes.
was.
And the lift was really old, and often there was like, the curtain sheets in there, and it was like you were going up to your sudden death. It was like, where am I going? But now it's not. It's in Goldman Street, in number 66. So look, when you go to NCAT, the process is pretty much the same every time you go. You have your paperwork. That's what it means for agents. It's a lot of paperwork. And then you sit in front of a court member. They don't have a wig. It's not like on TV. Everyone sits in the room together, all the cases together. And what
Right.
the member does is call out all the applicants and who is the respondent. Now, when you're an applicant and you're a tenant, you think, I'm taking the agent, or you're angry at the agent or the property manager, but you're never taking the agent, you're taking the landlord. So when you're a tenant out there and you're doing an application, just remember they'll correct you when you go to NCAT anyway, but you are taking the landlord. We have a managing agency agreement. We work on behalf of the landlord.
We're the
And
hand.
yeah, exactly, exactly. So, I've seen applications with, Mark Novak's name on it, my name on it. They'll put the ABN of the business on there, and then that member just says, like, who is the landlord? What is the property? And that paperwork gets amended for the landlord's name, because that's who you are taking to NCAT essentially. It's the landlord. Anyway, so they call out all the names, and you may really think you're going to get heard on that day. But the member says straight away, if both parties are here, you need to go into the conciliation rooms, and we'd like you to negotiate or attempt to negotiate on your own. If I get involved,
After, after you've walked through a metal detector,
oh yeah, you go through the metal detector, and there's security there with, I don't know if they're guns or they're things like, tasers or something, but they've
which
got
is because
weapons.
yeah, like you could imagine some like neighborly disputes really getting personal. So it's like, you arm up before you go in.
I
Um,
know, I know. It is, and it is a bit daunting, and sometimes there is a lot of hatred in the room. I, go in to NCAT with the same mindset always, that we're there to represent either the client or to help the tenant and get a resolve. You can contact the owner at any time. This is what the tenant's offering. Are you happy to accept that? When you go into the conciliation room, you have to sit there with the tenant, and sometimes the owner's present as well, because sometimes they like to come, and that's totally fine. And then you have to hash it out between yourselves. And sometimes that can get really personal, and tenants get their back up, or they haven't been through this process, or some have been through the process a lot and they know exactly what they're doing. But then a tenancy advocacy member comes in. So they're basically a lawyer for the tenant, and they sit there, but they also work for NCAP. So they're like, if we can tidy all this up without having to sit in that room with our very expensive member, we will try and do that. So they sit there and they hear the tenant out, they hear the agent out, and it'll all come down to facts and legislation. Well, no, you can't do that. Or look, what does the owner really want? Would they be happy with this? Sometimes they negotiate the date. If the tenant says, I haven't found anywhere, they'll say, all right, do you reckon you'll find somewhere in 2 weeks? They go, no, I might find something in 4 months. They go, well, that's not going to happen. So then they somehow try to get you to meet in the middle. I probably 99% of the time end up negotiating in that conciliation room, because I do prepare the landlord not to take a loss, but to be accepting of the process. It's not going to go, 100% your way ever. It never really ends up that way. So you have to be prepared to give. And then we negotiate in that room. If you can't negotiate, then they say, okay, we can't negotiate. You go in front of the member. The member will look around the room. There's usually about 5 other hearings on that time frame, and then they'll send you away for another 2 or 3 weeks. And they'll say, you need to give the agent all these documents, and you need to give that tenant all your documents. And once we exchange documents, the process can take a very long time. So if you're a tenant out there and you think you're just going to go there and get what you want and leave that day, the chances of that, it's like a golden unicorn. It never happens. So yeah.
So that little room that they send you off to, that person that keeps popping their head in the room is a member of the tribunal, and they sort of try to facilitate the agent conversation, the landlord conversation if they're tenant, and the tenant conversation. They're pretty accurate, those guys. Like, they'll tell you how it's going to play out, and you're like, oh, but no way, I'm going to. And then when it goes opposite the member, are they normally right, those guys?
I think normally they are, I think they're like an idiot detector. They come in there and they're like, if they think that someone's, not gonna play ball, they don't waste their time. They're just like, okay, this is gonna go in front of the member. They're not willing to give anything. So they come in there and they kind of test the waters. And I've, over the years I've got to know quite a lot of them. It's not personal for an agent, although it feels personal sometimes with the tenant, because sometimes you've built a rapport with these people for years. I've been to NCAT with tenants that have been in the property for 8 or 10 years, and it seems like a little bit of a defeat when you end up there. But as long as whatever it is that we do everything with as much integrity as we feel we have. If there's photos, if there's emails, if there's evidence, that's what we go by. And it's the landlord's wish. And it's not our wish, to take $1,200 from your bond or serve you notice, or it's just the circumstance at hand. Um, we are the messenger. So, and the same thing goes with the landlord. If they are disappointed with the outcome, it's out of our hands. There is a certain amount of leeway that both sides are given, but no one walks away victorious, put it that way.
Yeah, right. So before we go, any last words on tribunal stuff?
Um, I am looking forward to using AI this time. I'm going to put all my documents through AI and say, can you formulate a table numbered, with an index, all that stuff we hate doing as property managers.
Sorry, sorry. That's my
uh,
Law and Order coming on. So, what did you say?
I'm looking forward to using AI to formulate my documents, because I don't have a lot of time. So I'm just going to pop in all my evidence and say, can you make this a table and number it, and just all that tedious stuff that takes ages to do. So I'll see how that goes. I'll let you know.
Thank you for sharing all of your IP, not all of it, but some of it on tribunals, and good luck out there. It's a minefield. Thanks, Cleo.
Bye.
Take care. See ya.